Welcome to the Legal Corner. Today's show will be discussing what to do when faced with insurmountable debt, when is bankruptcy appropriate or not, as well as housing violations. What a show we have for you today. As always, I am Luis Trujillo. With me is my partner, Brian Levine. And again, this is your Legal Corner.
Before we get down to business, I just want to do a little housekeeping. I want to give a big shout out and thank you to our producers, Banjit and Jasdeep Singh. We couldn't be here without you. The information presented on our show is for educational purposes. Nothing should be construed as legal advice. Every individual case is different depending on the unique circumstances presented. It's important that you sit down with an attorney to discuss your individual case with them. But you could walk into your lawyer's office and say, you know what? I was hanging out this weekend with my favorite attorneys, Brian and Luis, at the Legal Corner, and I heard this.
The best show ever.
So give us a call.
At 1-800-870-6507. That number again is 1-800-870-6507.
Like always, we're here taking questions,
answering your calls,
laying it down. Last week, however, we got a lot of phone calls, and I want to get into those. I had a couple of very interesting calls. However, I had the oddest experience in my office this week.
This was a doozy. What was it?
It was ironic because last week I went on a diatribe about the importance of not waiting and about getting an attorney who actually knows what they're doing and not just going the loan modification route, and about, not having an attorney who's simply applying for a loan mod and not doing anything real with your case.
I.e. using your time and resources wisely.
Yes. Well, client came in yesterday, hands me a summons to complaint, tells me, what should I do? And I look at it, well, how long ago did you receive this? Well, I just received this, and I maybe about 5 days before. But she said that she had an attorney. The attorney was doing a loan modification, and they were denied. Needless to say, I got into a conversation with her, and she informed me that she gave the attorney $1,500 for a loan modification, and then after the modification was going to be approved, she would then be required to pay the attorney $2,000. She said that she retained this attorney about 2 months before or 3 months before, way after the change in the law regarding upfront fees. I did tell her, yeah, you should probably call that attorney and get your money back.
Absolutely.
To which her response was, I can't get in touch with the attorney. She just disappeared. It's just odd. I said, maybe the attorney got disbarred. I do not know.
Wah, wah.
But it's a good thing she ended up at my office because it was early enough. It was before the time to answer expired. And the bad thing is she lost $1,500. The good thing,
she found the right office.
She found the right office.
Just in time. She's left with 15 days yesterday, 14 days now. Someone's got to get an answer out to prevent her from defaulting.
And I'm doing right by her.
Absolutely.
Helping her out financially because she was taken advantage of.
Brian, before we get into the details, I just want to mention to our listeners that in New York State, ethically, it's not allowed that an attorney take on your legal foreclosure matter with just the fact that he's doing the loan modification. We attorneys here in New York State must take your distressed property case and work it from all aspects. That is not to say that you cannot hire an attorney who decides to put your defenses up, represent you in court, and on the side decides to help you with modification. That's acceptable. What we're meaning to say is that an attorney cannot just take the modification end of your case. And if you really think about it, it's counterintuitive, because if the attorney is only engaging and negotiating with the bank, here's the kicker. Who's going to court? Who's filing the necessary paperwork in court?